Let's discuss transferability and liability. As we know, a holder is a person who possesses an instrument payable to bearer or to the identified person possessing it. Holders have ordinary rights. They acquire rights, they acquire liabilities. They must defend claims and overcome defenses. So who you really want to be if seeking payment on an instrument is a holder in due course. A holder in due course takes a negotiable instrument free of all claims and most defenses of other parties. For a holder to become a holder in due course, they must meet certain acquisition requirements. The requirements for holder in due course status is the holder of the negotiable instrument. You have to be a holder of a negotiable instrument or a holder of an instrument soon to be a negotiable instrument. That you would have given value for it, that you took it in good faith without any notice that the instrument is overdue, been dishonored, that it is subject to any claim or defense, contains unauthorized signatures, or there's alterations, anything that calls into question the instrument's authenticity. The gist is that a holder in due course honestly pays for the instrument and does not know anything's wrong with it. So the holder that we just defined, we know what that is. That's the person who possesses an instrument payable to bearer or to the identified person possessing it. Let's talk about what constitutes value. What constitutes value? A holder in due course has to have already done something in exchange for the instrument. We have value given if we have one of the following. First, transferred for promise of performance, to the extent promise was actually performed. Future performance does not count. So an example of this, you go to work, you get a paycheck, you get paid for the work you perform. If I negotiate a $2,000 note signed by Gordon to you on your promise to perform landscaping work for 1 year, this is not work already done. This would be a future performance. It hasn't happened yet. Number 2, takes the satisfaction of a previous debt. Ivan owes Marta $2,000 on a past due account. Ivan negotiates a $2,000 note signed by Gordon to Marta, and Marta accepts it to discharge Ivan's overdue account. Has she given value for the instrument? Yes, from a previous debt. Number 3, gives another negotiable instrument. For example, a promissory note for a check. And number 4, acquires a security interest in the instrument. We call that chattel paper or other lien. So for example, I own a car dealership. I also finance cars for customers who buy cars from me. Customer Bob issued a note to my dealership as payee, promising to pay $15,000 due in 5 years from the date of the note. A month later, I borrowed $10,000 from a bank so I can do upgrades in my dealership. I give the bank that I borrowed the money from, a security interest in the note from Bob. So if I don't pay $10,000 to the bank would be entitled to Bob's payments. Another example, or let's try this example. Mary's given a $1,000 check for her birthday from Uncle Tom. Is Mary a holder in due course? No, she didn't take that check for value. The instrument she received as a gift, or if you get something that's inherited, you're not going to be a holder in due course. Value does not have to be for the full amount of the instrument. So what do I mean by that? It's going to be reviewed as a reasonable discount. So this is better with an example or two. The purchase of a $1,000 instrument in good faith for $950, the courts and under the UCC, this will be considered a reasonable discount. Purchase of the same instrument for $500 when market conditions show that the discount's excessive, probably not going to be considered in full value. One point I want to make before we leave value, during the financial crisis of 2008, instruments were being sold for pennies on the dollar, and that was considered reasonable at that time. Another requirement to become a holder in due course is good faith. which means honesty in fact and observance of reasonable commercial standards of fair dealing. So honesty in fact, and the transaction has to be commercially reasonable. So let's take a couple examples. Ralph issues a check payable to Paul. Laura steals the check, endorses the back, and presents to Quick Check Service for payment. Quick's employees compare Laura's signature to the signature on her ID. That matches up, right? Nothing indicates that the check is stolen. If Quick takes the check, could it become a holder in due course? It's a good faith, honesty in fact here. It's a subjective test. What is Quick Check Service thinking? That's the subjective test. This is probably good faith. Rand purchases a $10,000 note for $200 from a stranger on a street corner. Is Rand a holder in due course? This should be a huge good faith red flag right here. Suspicious circumstances. Is that reasonable commercial standards, buying notes on a street corner from a stranger? This is how we determine good faith, by these two components. And the final requirement to become a holder in due course, if a holder knows of any of the following things, the holder won't be a holder in due course, and they take the instrument subject to them. So they have to be without notice of these. That the instrument's overdue, or it's been dishonored, or that any person has a defense or claim of ownership to that instrument, or contains unauthorized signatures, or there's alterations calling into question its authenticity. So if any of those components exist, the holder will take subject to those. What constitutes notice? When a holder has actual knowledge or reason to know, and we're measuring this by what an objective person would think under the circumstances, a reasonable person would think when they're taking the instrument. A holder in due course status is determined when the holder receives the instrument. If at the very moment when he or she takes the possession, the holder has no notice of outstanding claims or other defects, then that person is a holder in due course, no matter what else happens afterwards. Even if the holder in due course learns of a claim or defect 15 minutes after receiving the instrument. So they either have to have actual notice, or based on the circumstances, a reasonable person would think they should have had notice. Otherwise, they take the instrument free and clear without notice. Any negotiable instrument is either payable at a definite time or on demand. Anyone who takes a time instrument the day after its expressed due date is on notice that it's overdue. So, for example, Ed signs a note due on May 15th. The note must be acquired before midnight on May 15th. If it's purchased on May 16th, purchaser is a holder, not a holder in due course. Instrument reads payable within 30 days. Counting begins on the day after the instrument is dated. So Dean signs a note dated December 1st that is payable in 30 days. When is the note due? Midnight, December 31st. Payment date falls on a holiday or a Sunday. It's payable the next day. I offered to sell you a $1,000 note for $9,000. The note was payable last week. This should be a red flag. You could demand payment already from the maker, right? Why am I trying to sell it? And for less, right? You're not going to be a holder in due course if you take that deal. Dishonored means an instrument's not paid when it's presented to the party who should pay it. They're failing to pay it, or they're saying they're not paying it. A defense and a claim, they are two different things. A defense is the reason why an obligor won't pay it. Let's say they're a minor, underage, and it's something they shouldn't have done because of their age, or they were incapacitated at the time that they entered into the instrument. A claim is an assertion of ownership in the instrument or on the instrument, and an example of this could be somebody had forged a name, and then the person whose name was forged saying, hey, that's my instrument. The key to liability on a negotiable instrument is the signature. Generally, every party, except the qualified endorser, the without recourse, who signs a negotiable instrument is either primarily or secondarily liable for the payment of the instrument when it comes due. Liability is going to attach if signed or signed by an agent on someone's behalf. The holder of an instrument must first ask for payment from those who are primarily liable before they can make a demand against anyone who is deemed secondarily liable. Who is primarily liable on a negotiable instrument, meaning they're absolutely required to pay the instrument, subject to certain defenses? The maker of a note. It's an unconditional promise to pay the note when it becomes due. The primary liability is unconditional. It's immediate when the instrument is signed or issued and effective when it becomes due. You make a promissory note to me that's due in 30 days from now. 30 days from now, I demand payment from you. You are liable to pay. Before we get into checks, we know that we have sight drafts and time drafts, and we also know that those could be an individual who's a drawee or a company that's a drawee. It's not a bank, right? It's not a financial institution. When we have those types of drafts, that drawee is going to be primarily liable. But when we're talking about a check, it's a little different. A drawer is secondarily liable, but that does not mean the bank is primarily liable, meaning the bank is not going to be liable to the holder, the one who's presenting the check, and they won't owe any damages to that holder for refusing to pay the check. They might be liable to the drawer per their checking account agreement, but that's a different discussion. The bank, when a holder makes demand for payment, they have two options. To pay the check, because we know the money comes out of the drawer's account. If it's there, it gets paid. If it's not, the bank's going to dishonor the check. So if it pays, it's all good. If it's dishonored, well, then our holder has to seek payment directly from the drawer. When we're talking about certified checks, bank is primarily liable, and the cashier's check, again, bank is primarily liable. I want to talk about the acceptor or drawee bank. They can be in this role of they give them the title of acceptor. It indicates acceptance by signing. They agree to pay the check when it is presented for payment. So for example, you provide me with a cashier's check for $1,000 for a car you bought from me. I bring it to the bank to cash it. Who's liable? Not you. It's the bank that issued it. This is the form of acceptor. They stepped into the role of acceptor. So the bank becomes primarily liable. So what happens if the primary liable party doesn't pay? Well, it falls to the secondary. And this kind of conditional, right? It's on the condition that our primary is paying or not paying. And we have our drawers and we have our endorsers. These folks have secondary liability. For notes, endorsers' second liability does not arise until the maker, the primarily liable person or company, defaults on the instrument. It means they don't pay. They don't pay. For drafts, drawers are secondarily liable. So you prepare and sign a check to me dated today. It's due on demand. I bring it to the bank to cash. If there's insufficient funds, the bank is going to refuse to pay it. Who's liable? You are. You make a promissory note to me due in 30 days from now. 30 days from now, I demand payment from you. You are liable to pay. What if the week after you give me the note, let's say within the 30 days, I negotiate it to a third party? They are a holder in due course. I'm the endorser. On the 30th day, the holder in due course comes to you for payment. You refuse to pay. They can come to me for payment if the following conditions are met. That the instrument was properly and timely presented, so within that 30 days time. Instruments dishonored, you refuse to pay. And timely notice to dishonor is, the timely notice of dishonor is given to the second liability party. So in order for the holder in due course to get payment from me, they'd have to give me notice first, and we're going to talk about timeliness of that next. What constitutes proper presentment? Well, entitled holder demands payment from appropriate party, who's the primary liable party, and that's really going to depend on the instrument when we have proper presentment. Commercially reasonable means, so it must be received. If it's a bank, we know it goes through a clearinghouse procedure for depositing checks. The process takes, 2, 3, 4 weeks for that to happen. I guess it depends on the banks and where they're located and such. And sometimes that can even be the place stated in the instrument. So commercially reasonable means being received can be through a clearinghouse for dealing with deposited checks. Otherwise, this place stated in the instrument. What constitutes timely presentment? On or before the due date, right on the due date. Demand within a reasonable time could constitute presentment. Regarding checks, you may notice that checks have dates on them. They may indicate a note that says cash within 90 days or within 6 months. Banks do not have to honor outside of these particular dates. What's dishonored? When the required acceptance or payment is refused or cannot be obtained within the prescribed times. Some examples: insufficient funds, sometimes not the proper signature, there's no signature. Proper notice must be given to those who are secondarily liable. The drawer on a draft, on a time draft, and a site draft, proper notice. They're on a non-bank drawee, and any endorser who is not the drawer of a check. We do not have to give notice. Basically what I'm saying is we don't have to give notice to a drawer of a check because it's their money. They would know, they're required to know that they have sufficient funds in their account. They know if they don't have it, that more than likely the bank is going to dishonor their check. That is their notice. But the common practice for the other folks, the endorsers and the drawee or drawer, the common practice is once an instrument's been dishonored, the holder must give notice to those secondarily liable that the instrument has been dishonored by the person or entity that is primarily liable. Notice must be given in a reasonable manner. It could be done orally, written, or in email. So let's take a look at this example. So we have Omar writes a check on his account at State Bank payable to Lee. Lee endorses the check in blank and cashes it at Midway Grocery, which transfers it to State Bank for payment. So who is Omar? Omar is our drawer on the State Bank check of the State Bank check. Who's State Bank? That's the drawee. Lee is the payee, also the holder. She endorses in blank, meaning she just signs it, right? So if she drops it and anyone picks it up, they could cash it, but she doesn't. She goes to Midway Grocery. Who is Midway Grocery? A holder in due course. How do we know that? They're holding a negotiable instrument. They paid for it. They paid Lee the amount on it. They did so in good faith. There's no information here that they don't know anything's wrong with it and no notice of any claims and such. So they're a holder in due course. So who is primarily liable here? Nobody, right? It's in limbo because we don't hold banks primarily liable. So there's two options. They got to pay or they got to dishonor. There's insufficient funds at State Bank, so they dishonored the check. Who's secondarily liable? Lee. To who? Midway Grocery. What must Midway do? Give Lee notice or a heads up. And basically that's going to mean, hey, this check was dishonored. Now you have to pay us, right? That's really what's going to happen. What if Lee wrote without recourse and then signed? She would have disclaimed liability. That would be a qualified endorser. So now Midway would have to go to Omar. But Omar does not need notice because Omar should know whether or not Omar has sufficient funds in his own account.